Martin, ഒരു മിനിറ്റ്. പൂരമാണ് കേൾക്കുന്നില്ല. ഇല്ലേ എന്താ കേക്ക ഓളിയും കറക്റ്റല്ല. എന്താ ക്ലിയർ അല്ല. കുറെ പേരുണ്ട്.
Hello, Father Martin. Janet.
Hello, good afternoon, Father.
Good afternoon, everybody.
Yeah, we are ready.
Good afternoon.
All are ready. We will start now.
Yeah, 44 people have come.
Yeah. Some more are coming.
Elrigu Jai Bhim, sir.
Hi. Hello, Anil. Kochu. Hi.
Good afternoon.
Good afternoon.
Mute all.
Good afternoon. Good afternoon, everyone.
Good afternoon, sir.
We are going to start the program.
Jai Bhim, sir.
See, if you go through the mission of the Indian Social Institute, we'll see that it is engaged in training the trainers. And mainly the stakeholders are Dalits, Adivasis, distressed migrants, community leaders, and various organizations which are involved in these kind of activities too. The cadre training and capacity building is one of the main focus of Indian Social Institute, focus area, thrust area of the Institute. And we have more than 55 partners with us from the different southern states of India to train the partners, to train the youth and build the cadres. Today we have the training program for all our NGO partners from the southern states of India. We have two sessions today. The first one is on the child safeguarding policy, and the second is on FCRA, the new amendment bill of 2020. We are very happy to see each of you here. A hearty welcome to each of you. The first session will be led by Father Joe Xavier, Director of the Institute. Welcome, Father Joe Xavier. Over to Father Joe.
Thank you. Thank you for coming together for this session. I know you have been meeting on various occasions on various current issues, and this will be specifically focusing on two important areas. As though they are not connected, one related to the finance matters, one on a policy matter, both are absolutely important. Basically, we have two things in any organization. We talk about two important policy matters. One based on Vishaka judgment, where in workplace, anything against the harassment of women in workplace based on Vishaka judgment, that's a policy. Every NGO, every institution, every organization is supposed to follow that. It's based on what happened for Vishaka in the workplace. It's called Vishaka judgment based on that, or protection of women from sexual harassment in workplace. That's one policy. The second policy we are talking about, basically many organizations talk about child protection. We are using the word child safeguarding, or much broader, we are using safeguarding of children and vulnerable adults. This is something specific to Jesuits and Jesuit-related organizations. While most of the organizations will use child protection policy or child safeguarding policy, we still broaden the scope of it, including the vulnerable adults. So this is where this context is. I will briefly explain because it's a policy matter. We will share with you the policy document itself. Every NGO, every organization is supposed to have, and the Indian Social Institute, Bangalore, has one policy in place. And we want to share this with all our partners because it is also linked to the partnership. That's why it's important we share with you the policy in brief. Then later you will have the policy in hand, you can go through. And today, more and more, we emphasize the vulnerability of the children and the vulnerability of the adult is a matter of great concern to all of us. I also feel, as much as it has become very, very strong in European and US context, in India, we feel the importance of it, but actually we have not really taken very serious measures. Despite you have the POCSO Act, despite you have the UNCRC, despite you have the JJ Act, the amendment, but still we have a long way to go because it is more to do with a mindset, a culture of safeguarding. So that's precisely the point. It is not a law that is going to sort of catch our throat or is forcing us, but a mindset and a culture that we need to develop in terms of recognizing the importance of children, their identity, their dignity, particularly of the vulnerable adults. So that's where this policy becomes important. I will share with you my screen so that I can quickly go through basically broadly the policy matter of it, and you should be able to get a glimpse of that. Okay, I suppose you can see my screen, correct? All of you can see my screen. Right, Arul, you can see.
Yes, Father. Yes, Father.
Yeah, okay. We are titling as safeguarding policy. More than safeguarding is much a larger, broader sense than just the protection of it. Safeguarding policy of children and vulnerable adults. And as I said, it is beyond the mandatory requirement of the child protection. It protects the children and the vulnerable adults. Children normally we bring below the age of 18, vulnerable adults even above 18, but if they are vulnerable, is the mandate that the Society of Jesus, we have taken it for ourselves, and we want to implement in all the organizations, endeavors, institutions that we are running. This becomes a matter of great concern for us. Now, one statement, if you ask me, what is the importance of it? It's a concrete expression of the Institute and its wholehearted commitment to the welfare, the protection, rights, and empowerment, or you call it development of the children and vulnerable adults who come under our purview, which means in whichever way. What happens outside, we may not be responsible. But within the institute campus, wherever we are having our partners, our programs running, that's all coming under the purview at all times and at all levels. It starts when and they say at all times, any time, any part of the time, that this becomes an expression of our commitment at all levels, from the management to maybe the maintenance level, from the visitors level, those who are entering the campus. It is applicable to all people, where we commit ourselves to protect, basically commit ourselves to the welfare, protection, rights, and the development, empowerment of children and vulnerable adults. That's in one word we can say this is broadly the very purpose of this policy. That's what we are trying to achieve and realize. So as I said, it has got 4 important components, this commitment. The institute will actively prevent child and vulnerable adults from abuse. That's one dimension of it. Remember, protection from abuse is a critical area. That's one major dimension of it. For me, yes, to reach that, the second dimension is very important. Can we promote an ambience, a conducive environment for the promotion, protection of the rights? That's where we are looking at many of the institutions where I promote, we write the code of conduct in. This is a child-friendly ambient space. This is here the children, vulnerable adults can feel comfortable. They feel that they are protected. They feel they are respected. That's called a conducive ambience environment. You can set up CCTV camera, you can do many other things, but an ambience is an important dimension. That goes with the very rhythm life of an organization. Then committed to prevent and deal with all kinds of abuses. Not just we speak in words, we also deal with them, the cases. I only hope when we have a good ambience, we may have very, very less cases of really people committing such efforts. If there's no good ambience, you have to deal with many more cases. So the idea is not to identify the case and deal with the case alone, but to promote a conducive ambience so that these things become part and parcel of the life and the organization and of the staff, so that such actions, such offenses, such abuses do not take place. And when you deal with them, that last dimension also, it doesn't speak only with the words, it also enters into action against any staff, associate, visitor, vendor, trader, business fellows who comes and goes, donors. Everyone is covered. Everyone is covered by this policy. Oh, these are donors, they give us money, how can we act? No, everybody has to abide by this policy, including the donor, including the vendor. So it's not just meant for the staff, it is meant for all sorts of stakeholders who come and go, who visit the institute. That's why you have the registration of notebook at the entrance, who has come and gone. Okay. What happens outside family, we may guide and motivate them, but we are not strictly responsible. But what happens within the campus and the institute, in the institute, or now, for example, now outreach staff are coming to the program part of it, to many of the Tiruvannamalai, so wherever it is, to Andhra, Hyderabad, wherever our works are taking place in partnership, this is applicable. So we want our partners also to read, understand, promote this culture of protection of the children and vulnerable adults. That's the commitment that we are making. Rationale is, of course, we know, despite many laws, the risks, the amount of the abuses children go through have increased. So there's a need to respond, particularly much more when we say we are a humanitarian organization, NGO, development organization. We need to advocate and strive to settle the highest achievable standard of rights of children, both in terms of physical, moral, and intellectual, and protection in the organizational work culture. This should become part of the organization's culture. That is what we are trying to promote. We have to be highly, highly sensitive to the children, their situation, their identity, their dignity, and of the vulnerable adults. Aim and scope, it basically revolves around how do we protect them at all times? Education and awareness. How can we do it otherwise? Can we promote participation as a key priority? Can the children speak out? Can the vulnerable adults speak out? What are they going through? Oh, you children, you don't know anything. Oh, they know much. They can speak. They can articulate what they're going through. They know what the drivers, that cleaners, that staff, that director, that male staff, female staff, what they're doing. They know. They are scared. But if an ambience, they will grow in maturity, physical, moral, and intellectual, they will become all-round developed person. So their participation is a key. And also, there is an active responsibility to be taken to promote and defend the rights of the children and vulnerable adults. This is what I mentioned, this code of conduct. In many institutions, we will also promote this. We write in big letters, not just enough to keep a complaint box, but also protect. This is child protected area, where these children get respected and they will articulate. You can't just enter and go out like that. So you can have number of code of conducts, the way the visitors, the staff have to behave, that is expressed openly and very clearly in the institute campuses. Then we also have the scope is as the law is developing with the POCSO Act, with the JJ Act. Now we need to really understand, imbibe the spirit of it, and what it tells us in spirit must be implemented in all our the way we govern, organize, the way we promote our own so-called NGO or development activities. We need to incorporate them. So this is not just a project, but it should become part and parcel of our way of life, the way we organize and function, the way in the organizational culture. The protection of the children, safeguarding of the children and vulnerable adults is a core dimension today. That's what we are trying to do. I will not go into the details of it, just mentioned, but I'm sure many of you had a class on this. UNHRC talks about the age, non-discrimination, best interest of the child, the right of the child to survival, development, all of the protection, education, protection from child labor, sexual exploitation, and detention and punishment. It deals with that. Basically, the four core dimensions are right to survive, right to development, right to protection, right to participation. Remember those four key terms: right to survival, development, protection, and participation are critical to the children. So that's very important from the United Nations Convention on the Rights of Children. POCSO Act, again, it's a very, very special, act which came into being in 2012. It talks about how to protect children from different forms of abuses, including penetrative and non-penetrative assault. Both, it need not be penetrative always, sexual abuse, non-penetrative, as well as sexual harassment and pornography. These are critical areas. You have them in different chapters. There are, what is it? What is penetrative? Aggravated penetrative sexual assault, sexual harassment, pornography. We are aware of it, how children are being lured into pornographic pictures, purposes, and into abuses, abetment, procedure for reporting, procedure for recording. These are all both technical, and the special courts established to deal with them. Then you have Juvenile Justice Act. Also, it protects not only the rights of the children, but a person's right when he or she was a child. You may be 20, 30, 40 years now, but you can even, that's what is becoming a big issue in US and Europe. When I was a child, I was abused by so-and-so, and the case will be taken up. That's the area we are running. So just because you have crossed certain age, if it has been, you have been abused as a children, the child has the right to complain even later. Okay, now even the age we say technically 18, both according to UNCRC and according to Indian law, but with Nirubhaya case and many other heinous crimes that are committed below the age of 16, there is an amendment to include 16 to 18 to be tried as an adult who are involved in heinous crimes. Okay. Basically, the Juvenile JJ Act talks about care, children in need of care and protection. It's an important area, and also juveniles in conflict with law. That's why you have the CWC, the Child Welfare Committees being formed at every district level, state level, so that the care, treatment, protection, rehabilitation, and development of the children are ensured. You may have differences of the working, it varies from state to state, but these are the organs, state-promoted organs, to really protect and promote the dignity, rights, and also working with the children, safeguarding them from abuses, all sorts of abuses. So that's where the role of the CWC, the JJ Act, POCS Act, all aimed at one thing. You will see the best interests of the child. They go in survival, right to survival, development, protection, and participation. Under that broader umbrella, you have many other laws being they have come into force to really look at this. Children grow in safety, security, so on. I will not go into much of the details. You have number of terms used. What is a child, juvenile? What is child protection? Protection basically deals with violence, abuse, exploitation. Like the child sexual abuse, as you know, POCS Act. We as Jesuits, which is beyond the ordinary law, we also include vulnerable adults. I think this is specific to the Jesuits, the Society of Jesus, who runs Indian Social Institute, and many other colleges and universities and institutions. A vulnerable adult means a person who is unable or unlikely to report sexual assault, sexual exploitation, and or sexual harassment, unless assisted in doing so due to impairment of mental or physical function. Please remember, it's a very broad definition because protection is more important, the development is more important, or due to unequal power relationship. Just because somebody is a director, just because somebody is an appointee, just because somebody is appointing you, no, if I say something, this fellow is losing me, reporting, I will be checked out. That's where it comes. Unequal power relationship with a person in position of power, authority, or in control of resource. Oh, if I say something, he will treat me differently. No, that's where the vulnerable adult comes, who seeks to accept, to provide protection, assistance, or service in exchange for sexual acts or favors. It also includes taking advantage of a position of vulnerability, differential power, or trust for sexual purposes. So all these are broadly covered. So you understand this, you have an office, you have an NGO, you have an organization, you have an institution. Obviously, there are some in the positions of power and who are working. And on a matter like this, everyone is equal. One cannot use any way, unduly or overdue, whatever way, use this power and authority for other purposes, like sexual purposes, and treat them, and these people become mum. That's the meaning of a vulnerable adult. So please include not only child safeguarding, also safeguarding of vulnerable adult is the premise of this policy. That's the character of this policy. Types of abuses, physical abuse, action or lack of action within a reasonable control. It's both action or lack of action. That within your control, you should have acted, you did not act, there's a physical abuse, then you cover. Sexual abuse, basically intention to gratify the other person. That's what it is. It's a gratification. Even a look that really destroys the other person, a touch, all that can be leading to sexual abuse, unless it's an acceptable behavior. These are some gray areas, but one needs to really understand why and for what. It starts with a touch, then because it leads to certain gratification, the ultimate purpose. So that's where what the right of the woman, the right of the child, don't touch me, do no harm. So that's where your assertion has to take place, because the child or the woman or vulnerable adult can sense the purpose of the other and say, stop this. That's where it stops. Okay. Otherwise, it leads to other complications. Then it really becomes an abuse. Mental emotional abuse, ill treatment, belittling, ridiculing, denigrating, labeling, many things. Negligent treatment, exposure to dangerous situation. You can't expose a child to a dangerous situation. No, take a risk like this. No. Development is different, risk-taking, unnecessary, dangerous situation. Exploitation, child labor, child prostitution. Violation of children of their privacy, private data. Data, you have seen Now in Europe and US, the data privacy has become a big issue with the internet and all that. India is picking up. The privacy is an important matter. Nobody can touch the privacy. Then you have media, pornography, internet images, how the children be used, misused. All these things are an important areas where lots of abuses take place. All these are given in the policy, you can go through. One dimension which doesn't fit into it, just want to say, though we will get into action, I think the humanitarian wise, the counseling part of it plays a major role. Counseling, it involves motivation at different levels, affirming persons' vulnerability, saying, no, you need to articulate, you need to say, and both the abuser and one who abused both require counseling. That's why I say it's a promotion of a culture than catching the thief and punishing. Yes, that is important, but I think fundamentally, if we want to promote a culture of safeguarding, we need to do a lot of groundwork so that eventually it is done. There have been lots of murders taking place. We have been punishing. We have been even going for capital punishment, but it has not stopped. Because why? The women have been exploited so long. It still continues. The Hathras case, the Nirubaya case, everything. Why? The culture of protection, the sensitivity with which we need to deal, that is not there. Such violations will continue. While the punishment can serve as a form of deterrence to some extent, but the culture of protection will be the right way forward, in which trauma counseling plays a major role. But still, if something happens, do you have a system? Yes, we have a system. In the institute, we have a protection committee composed of protection officer, who is a coordinator, and we have two other members, two are women in our committee. Then tenure, we have 3 years, renewable at the end of the term. Frequency, they meet once a quarter. They also organize motivational programs, awareness programs. We have done it already. So this is very important. And if there are cases reported, in whichever form it is, immediately the committee will act. Fortunately, we don't have. This does not mean we need to just be lethargic and lazy about it. I constantly tell the committee members it is their job to organize motivational programs. What is good touch? What is bad touch? No, many of these things we really motivate because it's important at different levels of stuff. Some may be more articulate, some may not be more articulate. Some may know, some may not know. Some may be acceptable in a particular cultural context, but that may not be acceptable in an institutional or organizational context. So it requires constant training. That there is a committee, we need to have it, and we are having it. The powers of the committee to ensure proper investigation, suggest penalties, and provide advice to the management for action. Because the committee itself will not be able to they cannot dictate the punishment, but they will suggest penalties to the management, and the management will go by the committee's recommendations. And it will notify the institute, informed of the progress of the case, because sometimes if the case takes longer, they will keep us informed, the management informed. Now, based on this, there are a number of actions which can take place. It is not mutually exclusive options. Probably one or two or more could take place. Maybe a warning letter, maybe a suspension without pay, with pay, maybe a transfer of the position, termination of service, and mandatory reporting to civil authority. These are all some gray areas, but we need to carefully. Such things, when we go out, the institute is responsible. So it is, we may not just, we may do termination of service, we may also report to the civil authorities. We may do transferring, but we may also say like suspension without pay. So you can adopt any disciplinary action. That depends upon the veracity of the case and how maybe the person is, whichever way it is, and the committee has recommended the intensity of the case, what they recommend. It's a repeated case, warnings are given. So it all depends on that, but the disciplinary action will get into that. That's the power of this protection committee that we are doing. This is again mandatory because I'm talking to NGO partners. What are we looking for from you, from the partnership request? You will be signing, already you have signed, in the MOU, this will be a major class. If you don't sign this, we can't take you as partners, as simple as that. I want to make this very clear. If you have to say that you will abide by this policy and you will implement this and comply with all sorts of child protection measures in your organization. And you will ensure your actions are open and non-secretive. There's no hide here. It has to be transparent. Ensure staff and visitors keep safe and respectable distance when interacting with children and vulnerable adults. This is where the code of conduct, the culture of developing will take place. Ensure no child vulnerable adult is employed at office. If we find the children are being employed, we say, thank you for your partnership. We will not be able to partner with you. These are basic requirements. Treat children with respect, regardless of caste, gender, language, recognize your right and personal privacy. And also, in your recruitment and reference, in your recruitment policy of the staff, we would like to see this is class. For example, in the institute, every staff would have signed this document. They know it, everybody has signed. Because also when somebody applies for a job, we check the background. You can't say, we were not aware of it, this particular person had already this background. You should have a reference background so that you ensure that your organization is safe, that your organization abides by the safeguarding policy of the children and the vulnerable adults. So these are mandatory requirements for partnership. I will be, and the institute will be emphasizing these things in the days to come, because this is critical for us, for the Society of Jesus, not because just for us, because it's important from the human dimension point of view, especially in reaching out to the most vulnerable groups. Okay. Standards, elements of safeguarding policy. Safeguarding policy should contain elements from ISI policy. I wish each one of you have a policy document for your own organization. You can take most of it because this is something we don't need to reinvent the wheel. You can use our own policy document and make it your own context. You need to publish it. You need to tell your members, contact details, everybody, visitor, vendor, donor. We have a policy. That's a basic need of it. Then ensure in the project, whichever, as you do the project, that becomes, so we are human persons, we are weak. Constantly we need reminders. So make sure once in 3 months or 4 months, you remind everybody of this. That's how you develop a positive, child-friendly, vulnerable-friendly environment in the organization. If there are cases of abuse, maltreatment, then take action. You set up a mechanism for prosecute them, take action according to your cultural and legal context. Then participation in empowerment, ensure children involved in their protection mechanisms. Allow children, nurture children to speak out what is happening, how they feel safe, dignified, protected, they are developed. Okay. This is, and allow their participation must be ensured. And the NGOs to empower them to protect themselves from any such of an abuse and maltreatment. That assurance, every child, every vulnerable adult in our organizational setup, we need to have. This is basically covers basically the broad areas. It's about 29 pages. You can go through the details of it. I am not here to give every detail of it, but just basically to introduce this and not just signing it, in practicing it. When we have an assessment of the NGO, we will be asking how many times you have conducted motivation session. Is there a visible sign of that your organization setup is adhering to this policy? Were there misuses? How did you go with that? This will become part and parcel of our partnership building. It is not only you will be asking, you can ask us. When there are cases particularly involving our own staff, you need to report to us and we will be taking the necessary actions regarding those steps. This is basically the policy matter I just wanted to share with you. I will stop my screening maybe for about a few minutes. If you want to ask any questions, clarifications, you are most welcome.
Over to Shujai, facilitator of Karnataka region, Karnataka state. He will be the moderator of the.
Thank you, Father, for sharing your presentation on child safeguard policy. You have covered up a lot of very much important definitions of the act and policy and all the other matters. Now I request our partners to raise the questions. If you have any questions or clarifications or suggestions, kindly you can unmute yourself and ask your questions and clarifications and suggestions.
What do you feel about this policy? Is that the right policy we should have? All institutions, organizations? Anybody to answer? Maybe we are hearing for the first time. Yes, go ahead.
No, no,
Yes,
if there are any suggestions also, you can ask. So you can share suggestions and questions and clarifications. Like Father asked, is this the right? Can we adopt this policy in our institutions?
I am Kausalya from ISI-B.
yes, go ahead.
We are already working in this field nearly few years before, and now also we are facing a lot of with the Adivasis and Irula people, and it is really good program to understand all these steps and to go through in deeper. It's really excellent. I want to thank Father. ISI is taking this initiatives. Really, it is great.
Thank you. And somebody else also has mentioned in the chat box, and you will get this policy of ISI policy to all of you. Please go through, make it your own. That's my request to you. Okay, I understand you will need some time to go through the policy. My suggestion would be, it is in your hands now. This is the culture of safeguarding of the children and vulnerable adults, which is very, very important for all of us, particularly that we say as a humanitarian developmental NGO organization. We need to show that we rise up to the challenging times of our today. And you can be in touch with the outreach facilitators or me for any details, and you can adapt this to your context. But that's going to play, all that I can say is going to be a critical piece in our future partnership development. So I believe that, which I also say we are accountable as much as you are accountable. So that's where the double partnership comes. We ourselves commit to this policy. So with this, I will move on to the next thematic area, which is an FCRA amendment. Let me introduce my friend here, my staff and friend. You will see him on the screen, Rajiv Kapoor. Rajiv Kapoor has worked for, I don't know, for more than 3 decades in Indian Social Institute, Delhi. Arul, you can mute everybody. Give us the correction so that. Yes. Okay, you are muted. Okay. Rajiv has been working more than 3 decades in Indian Social Institute, Delhi, as senior finance officer, and he has been a key person. In fact, the ISI Delhi, as you know well, it deals with lots of financial issues because it is nature, and he has been sort of a pillar down the years, really safeguarding the financial interests or financial dimensions or financial challenges of the institute. And I was director there. He was one of the key staff who I would always depend on him on the financial issues. And because of his experience and his own openness to talk to many auditors and get their views and come out with the real right sort of solution, he has been extremely good. Even now, my staff in ISI Bengaluru, I know, Father will ask Rajiv. That's all it is. I ask finally Rajiv. Then if both of us have something to clarify, I go to other 2 auditors. One is Martin, and the other one is Kadasamy. So we really consult and discuss, because many of these definitions are gray areas. We need really good inputs and good way to prevent that we don't get into very, very difficult times. And I'm really happy Rajiv has offered. He will briefly share with you for about half an hour, 30-35 minutes on what are the key amendments, FCRA amendments. I know some of them, it may be directly applicable. Somebody, it may not be directly applicable. Some of you may have questions and all that. Please feel free. At the end, he will be able to share his knowledge with us. Rajiv, thank you so much for accepting. You know, through us, you are reaching out about nearly about 40 to 50 NGO heads. These are our partners with whom we are working in South India, in Tamil Nadu. So we work with their cadres, and we also sort of work with the staff, the NGO heads. We make partnership with them. It's important they realize what it means, what the challenges are. Thank you. Go ahead, Rajiv. Over to you.
Just setting
Oh.
my PPT right.
Yeah.
Okay.
We saw the screen.
Okay.
I saw the screen. Just
Yeah.
share screen, open yours, share screen. It came and it disappeared. Click share screen down.
Yeah.
Desktop, click desktop, share screen, desktop, share.
It has come.
Share screen, desktop, share.
Yeah. Is it coming?
Not yet, not yet.
Not yet.
First, click the share screen down. Then you will see the whole icon coming. Click the desktop. Then click share. It came and disappeared. Who is with you?
Yeah, it's just assisting me.
Who is that? Who is that?
This is Mr. Arun.
Mr. Arun. Okay. Arun. Good, good. You click the share screen. No, share screen. You see share screen on security, participant, chat, share screen, record, reaction. Are you able to see? Oh, just a minute. Rajiv, you are struggling?
Yeah, he's trying to do. Just
What is he? No, it takes to 5 seconds, it comes. Yeah, go to full screen of Zoom, click share screen. Zoom call, Zoom, come to Zoom. Down you see share screen.
Otherwise, you can mail it.
You mail it, otherwise you mail it.
Or else you open the PPT first, then go to share screen.
yeah.
Whichever way. Just a minute.
PPT
You tell me what you're doing, then I'll explain.
PPT is open means then click on share screen. I mean, after chat, you can see the option called share screen. You can see the PPT and click on that PPT.
Rajiv, why don't you send me by mail? I'll screen it. I'm sorry for it's getting a bit delayed. Just technical features are always there.
So you can send the.
Yeah. I'm asking. Sujay. Just wait.
Oh, he left.
He left. You must have. Rajiv Z. Yeah, I'll call him. Just hold on, he's sending me by mail. Then I'll screen it.
Yes, he's joined.
Yeah. Let me get it by mail.
This one. कंटेंट हमारा जो है ना बिल्कुल ये हाँ अब ये पावरपॉइंट हो गया तो ये शेयर स्क्रीन
Have you sent it?
Yes, yes.
Ah.
I send it to you.
You sent it? Well, still, I'm not received.
This is sent to this ISI Bengaluru director.
No problem, no problem. It will just click immediately. It will come to my mobile. Now it's opening. Go ahead. You have got it. Go ahead, Rajiv.
Yeah.
Rajiv, go ahead.
Sorry for the inconvenience. Okay.
Yes, go ahead.
Reverend Father Joe, other fathers and sisters and dear friends. So I thank Father Joe for giving me an opportunity to speak on the recent amendments on FCRA, which came into effect from 29th September 2020. So while starting, before I start this one, let me just read out the government policy for the FCRA. So it seems that the government is not very much interested in welcoming the foreign receipts. So what was said in 2013 in the parliament is that the general policy of the government of India is not to encourage soliciting of foreign contribution. However, if it is intended for the bona fide welfare activities, foreign contribution can be received either by obtaining registration or prior permission from the central government under FCRA law 2010. So given this note, it's very clear that the more hard time might come in the future. So as we all know, on 28th of September 2020, there was an amendment, and the amendment was restricting the entity to further pass on the funds, whatever name you may call it, maybe sub-grant or grant or whatever, but it is prohibited now. So what was said in the Gazette, I will just read it to you, that they are saying under section 7, no person who is registered or granted a certificate or has obtained prior permission under the Act and receives foreign contribution shall transfer such foreign contribution to any other person. Now, while saying this any other person, it is already there in the PPT that the person includes what? By saying person, it means it is an individual, Hindu undivided family, an association, even company registered under section 8 of the Company Registration Act. So this is the definition of the person. So I mean, let me make it very clear that here, don't think that only entities are not allowed to. Even the individuals are covered under this definition of the amendment. So now, by saying this, now what is not allowed is the sub grants to another person. Person means it may be individual, it may be an entity, and then also refund of unutilized FC funds. Grants by Indian branch offices of international NGO who is registered under FCRA to another FC registered person or entity. Now, it means that any foreign donor NGO who has got a branch or office in India and who has already obtained a foreign contribution registration number with the FCRA authorities also cannot transfer the money because he is also registered under FCRA in India. So that's why he is not allowed to transfer the funds to any other entity. Then the transfer of FC assets to another as a gift or donation. This is not allowed now. Transfer by entity having multiple FCRA registration. Suppose one A entity is working in, let's say, 10 states and having a 10 FCRA numbers for all the 10 states independently. So now, by saying this, is that under the new amendment, the one A entity is one state office cannot transfer money or funds to another state. So that is also not allowed now. So what are the other changes that have happened apart from this is that the person who is granted a prior permission, if found guilty, can be asked not to utilize funds or not to receive any balance FC funds which is already approved by the government. And then now Aadhaar number, we all know. Aadhaar number now has become mandatory. And this will work as a identification document for seeking, it may be prior permission, it may be a registration, or it may be a renewal under FCRA, which is now is already on from 1st November onwards. The renewal is open. And then now what else is that now their government is I know in 2016-17 first they asked to register the Darpan, and it became mandatory for filing all kind of returns. The Darpan ID number we were quoting. In between it was stopped, but now again it has become active, and the Darpan ID number has to be obtained by visiting Niti Aayog website. So each NGO who has not obtained Darpan ID has to register with the Niti Aayog and give your organization details and get your Darpan ID, which has to be necessarily quoted while filing your FC4 return and also the renewal documents. And now this is Darpan ID for Indian NGOs, and then in case of foreigners, the copy of the passport or overseas citizen of India card is required as an identification proof. So government before renewing certificate can make such inquiry to satisfy that the conditions for registration have been complied with. So there will be a field survey, as we all know, IB inquiry or their own way of getting the information before granting the registration. And also now they are lowering down the administration expenses from earlier 50% to 20%. So which now we all find very difficult to manage with. But the idea was that to spend more for the activities and not earlier 50% means half of the money which is coming in can be used for the administrative cost. So government they think maybe it's too high, and then to lower it down to 20% instead of earlier 50%. Opening of FCRA, this is the other change, that now all the FCRA registered entities have to have the account open with the State Bank of India, New Delhi main branch. So this will be called a new FCRA designated bank account. Other changes is now the entity can also surrender the FCRA certificate. Earlier, this provision was not there. So now government says if any NGO wish that they want to surrender the FCRA certificate, can also do so. And but provided there are conditions, any unutilized funds or assets to be vested with the authority. Now here authority is very vague. Normally it is understood as maybe district magistrate. But then that government will tell you which authority or which department where to hand over these things in the case someone want to surrender the FCRA registration certificate. And in case of a suspension for whatsoever reason, in case of suspension of registration, earlier The time limit was 180 days. Now they are making it double. Just 5 days short of 1 year. So 6 months to 1 year. Now it means more time to suffer in that case. So these are some of the other changes which are also have happened. And now the message goes that the what is to be done now. It means we have to have a direct implementation of the programs, which means the donor agency, either the foreign donor agencies can transfer money directly to your sub grantees, like or let the organization itself undertake the program directly, entering into the field or wherever they were so far passing on the money by way of sub grant. And so by not doing this will be a violation. So it means if you try to twist here and there kind of indirect transfers from FC funds, it would mean violation. For example, if you give any advance to another person who then gives the bills to you, which means suppose you choose now instead of entity, you are choosing a person and giving him money in advance that to do your work and then to give the bills. It means the person may collect 8 to 10 bills, 2 to 3 bills from the various shopkeepers, and then to give you the count. So it looks as instead of giving money to the entity, now you are giving the same kind of financial support to individual person and getting work done would be violation. Giving an advances or reimbursement to another person for implementation of any program, that also will be a violation. But provided your own employee, you can give kind of advance or a reimbursement for the job to be done. And then making payment under a commercial contract with any other entity whose definite programs are cultural, economic, educational, as you are doing, any charitable organization does. And if any commercial entity is also doing this kind of a charitable program, cultural, economic, educational, religious, it would mean that it's again charitable organization and covering the face in the name of commercial contract or commercial activity, and then but it will be construed as a violation. Making payments to employees of any other NGO, but employee relationship continue to exist with the previous employer. I'll give an example. Now, suppose you are a entity and you are taking the service of an employee of the B entity, where the B entity has not technically left that his employer, and his PF, medical bills and all the dues are still remains there. It means there is not a clear-cut separation from the B entity. So therefore, that will not happen. It means instead of giving a grant to the B organization, you are giving money, same amount of money to his one of the employee to do all these works of your society, would mean a violation. Then also the staff of one NGO undertakes the works of the FCRA registered entity without resigning on the record. As I said already, that in order to do so, the person has to have a clear separation from the other organization to whom you are so far giving the subgrant. So the person has to resign and then can come to your side for doing your activity. Then it will not be a violation. Otherwise, it will be a violation. And then also now FCRA restrict the cash payment of more than 20,000 rupees and above. But here the catch is that the moment you think of making a cash payments of 20,000 and above, but you are again trapped in the income tax law. The income tax law does not allow you to spend cash more than 10,000 rupees. So therefore, now what to do? It's better to avoid cash payment. I don't know how many of you know that technically 3 to 4 years before, there was an advisory issued by the FCRA authorities, where the one of the advisory was that better to restrict your cash payments up to 2,000 rupees. That was the advisory of the Home Ministry. So what they want to, the idea behind it, this was that to monitor let your bank account speaks about all your transactions. That was the idea behind it. So I mean, in law, they are approving 20,000 rupees, but then you cannot really pay because then income restricts you. So therefore, better to be more by checks or NEFT transfer, RTGS, online internet banking transactions, or other means of online payments you can do. So, so as I said, the administrative expenses now not to exceed 20%. So what will happen if you do? So it means now first I will tell you the up to 28th of September you are allowed to, which you have already done. I mean till 28th August you have to see whether it is within 50% or not. And from 29th September onwards, the law came into force, allows you not to exceed 20%. So now the consequences. Now, if you spend more than 20%, you will not be considered as a charitable. So that is one punishment. You lose your charitable status. Or what you do, if you know you are definitely going to exceed 20%, better to take a prior permission from the government. And but the good thing is that suppose inadvertently you are exceeding 20%, so you can pay compounding fees for such amount which is exceeding 20%, and you get rid of this. So that is the remedy of this, which is a good side of this, because human mistake can happen, or sometimes it happens that we ignore certain things and then inadvertently we cross the limit. So there is a solution. You pay penalty, 5% penalty on the compounding fees, and get it regularized. Then now, okay, the question is the administrative expenses we have been talking. Now, what are the administrative expenses? So administrative expenses are payment to trustees, remuneration and other expenditures like travel to person, managing activities, program managers, etc. Remuneration and other expenses paid to these people, salary to the admin staff, including employees. All expenses related to consumables like electricity, water, telephone, postal, repairs and maintenance, stationery, printing, all this will be your administrative cost. It means you have to count all that for 20%. You have to limit to 20%. Cost of accounting and administrative funds, commission on funds raised, vehicle maintenance, cost of writing and filing reports, legal and professional charges, rent and repairs of the premises, and other utilities, publicity expenses, interest paid and bank charges, hospitality expenses, registration renewal fees, house tax, property tax. So these are the expenses incurred on salary of personnel engaged in training shall not be counted. Now, what is not a administrative expense is that any money by way of salary given to the personnel engaged for training shall not be counted as the administrative cost, because then it will be a program cost. So further explaining it, so it is said that the program expenses will also include the payment to surveyors, trainers, analysts, etc., and research and training. Expenses incurred directly in furtherance of the stated objectives of the welfare-oriented organization shall be excluded from the administrative expenses. It means you can do your program activities where you can make a payment to the surveyors, but here, see, if you're saying somebody is a coordinator, now coordinator is not a payment to the coordinator is not your program cost. It becomes a administrative cost. Same way, you may have a CEO or a project officer, but then so these are somebody who's trying to control your activities or supervisory post will not be a administrative expense. It will be rather program expenses. And then welfare spending. Now, because any NGO may have a program cost, welfare spending. Now, welfare spending is mainly for the health institutions and educational institutions. They are so-called welfare spending, welfare entities. So here, salary to doctors, nurses, teachers, health workers, etc. They are all that this all will be a non-administrative cost. So here you can claim 100% as your activity cost. Now here I am saying note that since I have already explained that till 28th of September you can incur up to 50%, and from 29th September till 31st March 2021 you have to be within 20%. By saying this, it is better that when you close your books of accounts on March 21, So better ask your auditors to give a note on accounting by saying, or even in the income and expenses account itself, they can write it two type of administrative expenses by clearly saying administrative expenses up to 28th September and administrative expenses 29th September onwards till March 21. So that you, while filing the annual return at the right time, will know what percentage of administrative cost it is on the total FCRA funds received during the period, during the year. So by saying all this administrative cost, am I speaking very fast or is okay?
It's okay, sir.
It's okay? Okay. Okay, now see the next thing is this is one of the amendments that as I said earlier, all the NGOs would have to open an account with the State Bank of India. So for that, what you have to do is that it has to be with the main branch, but then there is a circular from the State Bank of India saying that any entity, organization who's not in Delhi, they are registered out of Delhi or operating from out of Delhi, can give their documents for account opening document to their nearby branch of State Bank of India. And that branch within 3 days will scan and send all your documents to the this Parliament Street, New Delhi branch of State Bank of India, which is the main branch, which is nominated for opening the FCRA designated bank account. And so by saying this, now there are some of the things which you have to keep in mind while saying this. When you fill up the form for the state, see, thing is, what I want to say is that when you fill up your form of State Bank of India and hand over to your nearby branch, there are certain things you have to keep in mind. Why I'm saying is that your branch of nearby branch will send these documents to the New Delhi branch of State Bank of India. But in order to avoid further objections from the New Delhi branch of State Bank of India, you have to keep certain things in mind, which I'm going to just tell you that, while making a resolution, you have to mention whether you want to open the savings account or current account. That you have to mention in the resolution. So please just take a note of this. And also those NGOs who are not having a 12A certificate obtained from the income tax department, they cannot go for a savings bank account. For them, it has to be a current account. So you have to say very clearly in the resolution that to open a current account. You also mentioned in the resolution about the corporate internet banking to be obtained from the State Bank of India, because see, in the total bunch of papers, the forms, annexures, and all that, whatever the full set you're getting from State Bank of India, there is another form of corporate internet banking. It means the bank will give you the internet banking facility, whether you use or not. It's a different thing. But then, if you think, applying it later on, once your account is open and you think of applying it later on, then again you have to do all the same documentary facility formalities. So many documents again has to be submitted for the authorized signatory, for the organization. It will be a technically repetitive exercise. In order to not to do so, you better apply same corporate internet banking facility also, whether you use it or not. And then you also have to mention in the resolution the account operating instructions, whether it will be whether the account will be handled by singly or jointly or whatever or otherwise. That you have to see as per your society's bylaws or what the governing body feels about this. So also mention in the resolution that how many persons are going to sign the resolution. See, if you are a society or even a trust, there is a column of quorum. In your society and trust document, there is a column of quorum. So kindly read your quorum clause of your society MOA or trust deed, and see there whether it allows you to 1/3 majority or 2/3 or 3/4 or 3/5, whatever is written there. Accordingly, you see the size of your governing body members, whether whatever number of people are there on the governing body member, and calculate accordingly. Calculate your how many numbers of people need to sign the resolution and other papers, keeping in mind your quorum, the clause. I hope it is clear. All the key persons should have account with the State Bank of India. It means uh, uh, all your key persons like president, vice president, secretary, treasurer, or even any other person who is going to operate the bank account should have an account open with the State Bank of India and to obtain and attach copy of the passbook with your account opening form. So now, while doing this, we come across that many people, the signatories, their PAN details are not matching with the Aadhaar details. Now, once you give all your papers to the State Bank of India nearby branch, so there will be a rejection from the main branch of New Delhi, and you have to suffer by like a waste of time. You have to then comply to those things. Again, giving to this branch, nearby branch, they will further send it. So please make sure that your all the Aadhaar details and Aadhaar details match with your PAN card details. And same and also your account name in the State Bank of India should be the same. So these three things should be matching. Aadhaar name, PAN name, and your bank account name should be matching. Okay. Also, the name of the entity. Now, we also come across that there are few societies where the FCRA registration name is different than the society's name, which is the legal name. Because you all know the FCRA authorities in the past were allowing any unregistered NGO or any unregistered society to get the FCRA registration certificate. And then or even otherwise, sometimes we are noticed that there are 8 to 10 branches of the schools working under one province, and the province name is different than the FCRA certificate obtained by each school in each state. So given that the SBI New Delhi branch is not accepting your papers because they want to see same name in the FCRA certificate, which is your legal registration society or trust name. So that point also to be noted. And then also now what they started doing is the moment you go open the account, they will ask you to submit your Darpan this one documents. Darpan document is your Darpan ID, and also the list of members you have reported in the Darpan your Niti Aayog website. So make sure that your list of Gondi Body member which you are going to give to your State Bank of India for opening the new account, those members should match with your Niti Aayog website GB members reported. That also you have to make sure. And then you submit the copy of your annual return. If you are a society, you must be filing an annual return with your register of societies. So it means your covering letter and the list of Gondi Body members which you are filing with the register of society every year, you have to give the latest return filed with the register of societies. The copy of that also you have to give to the State Bank of India with all other documents. So these two are the the new changes they are communicating nowadays. The Darpan ID and the GB members list as per Darpan, and also the annual return filed with the register of societies reported the GB members. So these two things are the extra requirements, and now they are asking. So so that's why, as far as possible, the GB members should match with the and also see, last year many of you must have filed 6E form, FCRA form 6E. That is for reporting the changes of the key members. And it was in July or August sometime, 19 sometime, and for which the approval is still pending with the Home Ministry. Now, there are different views in the market. Some experts are saying we can change the president or vice president, whatever change has happened after filing 6E. Now it is a high time to report in FC3 renewal form. But then we are taking a very conservative opinion, and by saying this, I think it is not prudent to report a new change members in the renewal form, or even not to give a new list of Gondi Body members to the State Bank of India while opening this is your FCRA designated account. Reason being that if you all know, last year there was a very clear notification from the FCRA saying to take a prior approval before accepting a change in the members. So therefore, you cannot induct a change in the member unless the FCRA allows you to do so by way of applying and then granting approval to you. So since
Sir, just an
so we are in the same list of body Afghani body members even now while giving to the State Bank of India.
Raju sir, just a small interruption. Can you please change the slides?
Slides, okay.
Okay.
Okay. And no, this slide remains the same, but I was just, giving you extra information from this.
Okay.
Yes, sir. So, okay. So now here I already said that once the State Bank of India bank account is open, the future FCRA receipts must be received only in this bank account. That we all know that once the moment account is opened, we cannot receive fresh funds into the old account. So that is clear. Then the State Bank account will be a saving account. I have already said. Do not make transactions till approval. Okay. Now this is the thing. The moment you open a State Bank of India account, you cannot receive money into that account, but you have to apply on form. FCRA 6C form is there electronically. So there you have to apply to the Home Ministry by giving all your details of the new bank account of State Bank of India. And by my experience, within 2 weeks they give the approval. So the moment approval comes, then only you should think of receiving money in the new bank account. So that is all about this one. And then, so that's why I'm saying, do not receive further FCRA funds in the old account. So once you open a State Bank of India account, even whether you take approval of the Home Ministry or not, but you cannot receive funds in the old account. So that is also conditional. Whether so therefore. Practically, as per the law, within 15 days you have to apply for approval. But sooner is better because the sooner you are getting approval, you can start your activities in the new account. And that does not mean that you have to transfer all your money from the old account to the new account. That is not required. So you can retain the existing FCRA account and link it with the State Bank of India account, and that can be used for keeping and utilizing or making fixed deposits. So as I said, the existing bank account will become your keeping and utilization bank account later on. Once the State Bank of India account is open and you have obtained the approval from the Home Ministry, and then you start receiving fresh funds in that account. But the existing funds lying in your old FCRA account need to transfer. That you keep on utilizing till you get the approval or you get the account details from the State Bank of India. You can do so. So as I have mentioned already, the voluntary surrender of FCRA certificate. So the FCRA authority has come up with a new form FC7 where you can apply for a surrender of FCRA certificate. But then there are a few conditions of the government. So they are saying they will make an inquiry to verify whether the FCRA entity has contravened any provision of the Act. So they will make inquiry and then only allow you to they will accept your surrender of this one, number. The balance contribution lying in the FCRA account or utilization bank account will be vested with the prescribed authority. As I said earlier, it may be district magistrate, or they will tell to whom it is to be vested. The assets created out of foreign contribution over the years to be vested with the prescribed authorities. Assets also will be handed over. And validity of the certificate surrender shall be deemed to have expired once they accept you and give you the communication in writing that it is accepted. So from that day onwards, it becomes effective that your FCR number is surrendered and accepted by the government. So, okay, during a suspension period, I have mentioned earlier, now during suspension, which is now increased from 180 days to 360 days, here, what you are not allowed to do, you are not allowed to receive any or even you cannot spend money during the suspension. Number two, 25% limit FC spending with prior approval remains unchanged. It means you can only spend 25% from the funds you are already having till the time this suspension is taken back by the government. And then that will be happen only after having a summary inquiry from the FCRA department. So they can do two things. Either they can allow you, they can take back the suspension, or they can cancel your number. So once it's cancelled, the same thing applies, like you have to hand over everything to your to the government. So this is all about major changes, amendment. Then we come to the rules. And we all know apart from the amendments of Act, also there was an amendment in the rules which came into effect from 10th of November 2020. And they are talking about the prior permission. There are changes in that. The commitment letter from the donor has to come. Affidavit from all the board members, which is now mandatory. All the board members have to give the affidavit, which has to be uploaded online. Installment based permission will be given if your total permission is more than 1 crore rupees. Single application. If grant is going to be more than 1 crore rupees project, and then they will give you in it will be installment based. And the second or subsequent installments after utilizing 70. Okay. So once you receive the first installment, you have to spend 75% of that in order to ask for another permission for this subsequent installment. And the fee for applying for prior permission is 5,000 rupees. And then suspension during prior permission. Suppose during prior permission something happens and the government noted down something and they are not happy, so they will stop you doing activities. So permission can be suspended after inquiry. And suspension is applicable to stop receipts of further funds or even spending. Even they will not allow you to spend money from that day onwards. So only thing is prior approval is required. When you want to spend a certain money, you have to take the prior approval. Then same way, condition for registration. So organization has to be 3 years old. Earlier they were saying minimum 10 lakhs to be spent, but now they are saying 15 lakhs in the last 3 years on the activities for which you are going to sort the registration. So now, by the way, if you are not covered by 15 lakhs rupees expenses, you can also choose your local account, assets, and give a list of that, making it to 15 lakhs rupees. It means those assets which you are choosing from your local account and to be dedicated for FCRA use, that assets you cannot take back without the approval of the government. It means every year your auditors will give a disclosure that these assets are still dedicated for the FCRA activity and is not taken back and dedicated for your local account needs. That has to be kept in mind. And you affidavit from all the board members, I have already said, and then the applicable fees is 10,000 rupees for this one. Then extending the suspension period. Now that is already there, that even for permanent restriction, if something goes wrong and it is suspended, no FC may be received or spent during suspension. Only 25% of the existing FC funds has to be spent with the prior approval. So after holding a summary inquiry, they will either take back your suspension or they will cancel the number. Now this is something horrible that they are saying any organization who is habitually engaged in employ common methods of political action like Band or Hartal, Rasta Roko, Rail Roko, Jail Bharo, and in support of any public causes will be declared as a political nature and they will be banned. Their number will be cancelled and they will not be allowed to be a permanent registration society, and the number will be taken back. Now we are coming to the renewal process, which is already on from 1st November, and we all know that it will go within 6 months. FC 3C is the form. 3C is the form to be applied online. Affidavit to be executed for each of the office bearers. The fee is 5,000 rupees. Darpan ID, as I already said, is mandatory. So here, if FCRA not renewed before expiry, the organization may not utilize the remaining FC funds, nor it can receive further funds. This point to be noted. So therefore, it is in our interest to apply in time. But but before that, you have to open the account with the State Bank of India, as the earlier said, because that new account has to be reported in the renewal form. Other relevant changes in the rules is the office bearers as the key functional members to be intimated within 15 days in Form 6C, as we have already done last year, continues. And procedure and fee for revision of order issued Okay, any order is issued by the government. If it's not in your interest, you can file a revision petition by giving a 3,000 rupees fees and for reconsidering from the government side, which is a new and welcome thing. Then application and fee for compounding of offences. Suppose something happened, and you commit offence, then the chance will be given to you for compounding it. It means you have to pay a fine, and then you can be given a clean check. Instead of they cancel your number or they suspend your number, the opportunity will be provided here in the new rule. Extension of time for filing annual return. We all know annual return, which become due on 31st December every year, is now this year they have allowed it till 30 June because of the these all changes came from in the Act and rules. So government says file FC4 till 30 June. Also because of the reason that the State Bank of India account has to be opened by 31st of March by everyone. So therefore they are giving another 3 months to report the new bank details in the FC4 form, which is again mandatory, and the Darpan ID many have not got, so they have to apply. So keeping all the things in mind, they are giving a time to 30th of June 2021. So this is all about the new FCRA changes, Act and rules.
Thank you, Raju sir. Actually, it was a very insightful presentation from your side, and some of us were not aware of this new FCRA Act 2020, and you have clearly explained us the procedure, rules, conditions, violations, how this our FCRA account can be freezed, and then how to open an account, a new account, and which are the channels we have to follow. All that you have clearly stated to us. Now I request our participants, our NGO heads who are here with us, to if they have any questions or clarifications, if they want to ask anything, I request all of our partners to kindly raise their questions and clarifications. Any questions?
Sir, I think it was very informative. I think most of our partners will have a number of questions.
Yes.
But maybe we can ask later also, I feel,
Yeah.
because we will be giving the PowerPoint to all our partners.
Well, sister, here there is a request. The PPT which I sent to Father Joe.
Yeah, Father will be giving to us.
So
yeah.
It is a very brief.
Yeah.
I also have same thing in detail.
Okay.
So I'm going to send this to you and Father Joe.
Yeah.
And then you can further pass on to the people.
Yeah. Father will give. So we will be sending to our partners.
I will be sending to you and Father Joe.
Yeah, sure, Father.
Sure,
sir.
And you can send to all.
So in case if they have any doubt, we can also write to you.
Yeah, yes.
Maybe that is, I think, to it.
Maybe let them communicate to you, sister, or to Father Joe.
Oh, yes, sure.
Through Father Joe or you, it can come to me.
Oh, yes, Father. Yes, sir.
Sure.
No, I think if there are some. Are there any questions?
Sir.
Yes.
Good evening, sir.
Good evening.
Our group is registered with the society. So we are maintaining a local account for the society, sir, for the registrar of societies. So this account need to be with the new SBI, or can we maintain the old account with the bank that we are using?
No, sister. It has to be a new account with the New Delhi branch, as I said.
For the society of registrars too.
See, that may be your local account.
Yeah.
See, local account you can retain.
Okay, sir.
But we are talking about the new FCRA amendment.
Okay.
So, but do you have a FCRA account, a district FCRA account?
No, sir. We have one. No, not for the district. No.
No. What I mean to say, are you registered with the FCRA authorities?
Yes.
If you are registered with the FCRA authority, you may be having a FCRA designated bank account, existing one.
Okay.
So that will become your keeping and utilization bank account.
Okay.
But you have to open a new account for receiving further money in that account.
Okay, sir. Sure.
So for that, as I said, you have to open the new account, take a approval from the government, and then start receiving the funds in that account.
Okay, sir. Okay. One more thing, sir, regarding the salaries for the employees, we are conducting different programs, activities. So each activity has a coordinator, program coordinator and field coordinator. Those people's salary will be considered as administrative cost?
Administrative, yes, administrative cost.
For the field coordinators too?
Yes. Anybody who's labeled with the coordinator word is the admin cost.
Okay.
The idea is that, I'll give an example. Suppose somebody is a trainer.
Okay.
Now, trainer is doing a technical work of training people.
Okay.
So that's an activity actually. But somebody who's coordinating, it means he's not doing the direct activity, but only trying to control few people as a coordinator. So that's the administration cost.
Okay. Okay, thank you.
Raju sir, there is a question by Vasant. He's asking if you could provide some information about ATG and 12A.
Okay. Now, thing is,
how to get ATG and 12A. That's
how to get.
Yeah.
See, I'll just give you in a very short brief that first of all, let us understand what is 12A.
Yeah.
Now, 12A is a recognition given by the Income Tax Department, recognizing your entity, society, organization as a charitable entity. So as a charitable entity, you are allowed not to pay tax provided you spend 85% of the total current year's income for the objects of the society. Now, given this in mind, it should be a charitable welfare activities, and so while doing so, you have to apply online. Now there is an online facility for applying for a 12A, and you go to Income site and apply online for the 12A certificate. The time period is 6 months. Within 6 months, they will so you will be served with a notice from the Income Department for providing certain details like your past activities, your future activities, your bylaws, and your annual reports. So there are many information they will take from you, and just to see whether you are really a charitable or not, because that deals with the charitable status of the society. Now, coming to the ATG, ATG is basically, see, any charitable organization who's having a 12A is allowed to make a donation to another NGO who's again a charitable nature, having the same kind of objectives. Both the sides are allowed to donate money to each other. So, but then what is special in ATG? So the ATG deals with suppose any individual person or even CSR funding, they want to give some support to your NGO. So ATG is must there for receiving donation other than the society. So this is where the ATG plays a role. So both are is good to have ATG, but 12A is really mandatory. Without 12A, if you make any donation, will not be treated as a charitable activity, and that expense will be disallowed by the Income Tax Department, and you have to pay tax on that money. So it's really it's like dying, without having 12A.
And the same question from Vasant is that they are demanding 50,000 rupees for ATG, for 12A and ATGs.
There is no fee for there is no fee for obtaining 12A ATG certificate from the government. So there is no fee for that.
Okay.
Yeah.
Okay. Do we have any more questions?
Sir, Arul sir, totally ATG renewal pannangala.
It's a question from one of a partner from Tamil Nadu. Okay. He's asking whether we have to renew the 12A or ATG certificate, or is this a lifetime?
No, sir. Actually, now if you see these recent amendments brought by the Ministry of Finance, now under that it was supposed to be this year, but then now they are keeping 1st April 21 onwards. You have to, those who are already having in possession 12A and ATG will have to apply for the renewal of the same, which will be now going to be valid for another every time 5 years. Like you have a FCRA.
5 years.
Your FCRA is valid for 5 years. Same way, this also is going to be valid for 5 years. And and the due date is the 1st April 21 onwards.
Okay.
So sooner you apply, sooner you get the approval.
Okay, സിവിലിംഗം സാർ 5 സ്കോർ വാട്ടി റിവ്യൂ കൊണ്ടിരിക്കുന്നത്
Okay, sir. Okay, sir. Okay, sir.
Any more questions and clarifications? If not, then I will request Arul to propose vote of thanks. Arul, Tamil Nadu Outreach Unit Coordinator.
Good evening, everyone. So I am Arul Prakasam as a outreach coordinator from the Tamil Nadu Outreach. Here I am present a vote of thanks for this wonderful session. I would like to thank our guest speaker, Mr. Rajiv Kapoor, a financial consultant and experienced in the NGO finance for more than 3 decades and working with the ISI Delhi. And thank you, sir, for clarifying our partners' doubt, because most of the partners are FCRA, but they're not familiar with what is the amendment, as everything happened. So thank you for you. And I have to thank once again, because during a busy schedule, you spend the time with us. Thank you for that. And we will share your PPT that you're going to send to us. Thank you, sir. And I also like to thank our director, Dr. Joseph Xavier, come up with a new policy for the children's and vulnerable adults safeguarding policy. And we will be introduced to all our partners, and it has to follow for everyone, because recent days many violations happening for children. So we have to safeguard our next generation. So that's the reason we have introduced this policy. I'd like to thank Father Joseph Xavier for the presenting a wonderful policy for us. And I like to thank all the partner organization, directors and coordinators representing various NGOs from various states. And we thank you so much for us. Be with us, and we will send all the documents to you through mail or through WhatsApp. So thank you so much for this wonderful session. And we will also plan to have this in local language. We will send the document in the local language also. Thank you so much.
Thank you, sir.
Thank you all. Thank you all.
Thank you.
ವಸಂತ್ ಸರ್, ನಾನು ನಿಮ್ಮ ಕನ್ನಡದಲ್ಲಿ ಕಳಿಸ್ಕೊಡ್ತೀನಿ. ನಾನು ಹೇಳ್ತೀನಿ ಏನೇನು ಟ್ರಾನ್ಸ್ಲೇಟ್ ಹೇಳಿದ್ದಾರೆ ಸರ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ಮತ್ತೆ ಅದು ಕನ್ನಡದಲ್ಲಿ ನಾವು ಒಂದ್ಸತಿ ಆರ್ಗನೈಸ್ ಮಾಡೋಣ. ನಮ್ಮ ಕರ್ನಾಟಕದಲ್ಲಿ, ಕರ್ನಾಟಕ ರೀಜನ್ ಅಲ್ಲಿ ನಾವು ಕನ್ನಡದಲ್ಲೂ ಒಂದ್ಸತಿ ಆರ್ಗನೈಸ್ ಮಾಡೋಣ.
ಅರುಣ್ ಬ್ರದರ್, ಥ್ಯಾಂಕ್ ಯು.
Thank you, sir. ತಮಿಳಿನ ಅನುಪಿರ್ರೆ ನಮ್ಮ ಸೆಷನ್ ವச்சிரலாம். Okay.
Thank you. Thank you, Arun sir.
Thank you, sir.
Thank you, one and all, for your valuable and great information sharing with us. Thank you, one and all.
Thank you, Vasan sir.
Lakshman sir.